Hey everybody, I just want to take a few minutes and go over the final project guidelines and rubric. Um, I'm not going to discuss each of the areas because we've dealt with many of these in our previous assignments and I've left you some notes, but I'm going to go ahead and highlight some areas where either I think maybe there is um, still some confusion or areas that are relatively new. In other words, we haven't done a milestone paper on them, but we probably have covered it in one of our short papers. All right, so hopefully this will help. And I'm hoping to get this done in one short 15-minute video presentation. If not, uh, I'll do another short one, but hopefully I'll get it done in this one. Okay. So uh, what you need to do is make sure that you review the final grading rubric and also the assignment guidelines as you prepare your final project. The other thing you can do, I think that'll be a benefit, is to use this as a guideline, as an outline for your assignment. So as you prepare your assignment, your final paper, you can look at each of these as an outline. So outline one, judicial system, subset A, and here's what you need to do, and so forth. And then you can look at the rubric to see, to get an exemplary rating, this is what I need to do. Maybe I need to add an example. Maybe I need to apply some research. Okay, so that is probably the best way to do this because there are so many critical elements in this assignment that if you forget to do something, then I'll have to zero out that category, and you don't want that to happen. So if you don't use this as an outline, then at least please, when you're done with your paper, check each of these sections off as you identify them in your paper. Okay. Again, the key is just to make sure that you address each of these categories in your final paper. And the best way to do it is to, perhaps, like I said, use this as your outline. Okay. So I'm not going to go through the scenario. I'm going to go right into the rubric and highlight areas that I think I need to spend a little bit of time with for you guys. I think we all seem to be pretty familiar with the judicial system, the hierarchical structure. Go back, take a look at my notes. When we talk about the hierarchical structure, we're talking about typically the three tiers in the court system. We have trial courts, we have intermediate or appellate courts, and then we have Supreme Courts. So states and the federal government tend to operate on a three-tiered system, although some states might have courts of general jurisdiction and courts of limited jurisdiction, so you might have more of a four-tiered system. But nonetheless, identify what each of those tiers are, and then basically what is the role of each. So the lower tiers are typically your trial courts. The intermediate tiers tend to be your appellate courts, and the Supreme Courts of the U.S. and the states are the supreme law of the land and or the state in which you reside. Okay. The judicial system, their levels, we talked about those, the importance of having each level. They each serve a function. So take a look at your textbook, take a look at any other resources you have, and just so you're familiar with what each role, each level is responsible for in terms of the terms of the criminal justice system. Then we talked about subject matter venue. Again, we're talking about courts that, such as juvenile courts. We're talking about the specific courts, family law courts that deal with certain matters. These courts free up trial courts to address criminal matters. A lot of times these might be courts involving specific subject matter specialties, such as patent courts at the federal level dealing with patents and things like that. Okay, so spend a little bit of time in that area if my comment suggested that. Okay, jurisdiction. We talked about jurisdiction, so you know what jurisdiction is. Okay, it's basically the authority of a court to hear a case, and jurisdiction is going to boil down to whether or not it's a federal authority or state jurisdiction or federal jurisdiction. So you understand that. We've been talking about that specifically with the scenario. So I don't think that's too big of an issue. Venue, you guys did a pretty good job on venue and the implications of venue. Venue can be unique in this particular case because the crime occurred in Washington, D.C., for example, but our suspects were captured in another state. The venue, obviously, for the bank robbery is where we need to get our bank robbers back to. There are some implications, and often when you're talking about bringing in witnesses from other areas outside of the state, a court needs to make sure that it's operating in an efficient, effective manner, because you do not want to have out-of-state witnesses sitting outside a courtroom all day waiting to testify and told to go home when in fact home might be 200-300 miles away. Okay, so there are implications to venue and determining venue, and we discussed how venue was established and how it's determined. This is a federal bank robbery. You guys identified the court, United States District Court for the District of Washington, D.C. Okay, so you did a good job on that. You talked about venue for this case. Very good. Sentencing guidelines. Explain sentencing guidelines in federal and state judicial systems and describes their impact on functionality. So this gets back to the idea of mandatory minimums and sentencing guidelines. Okay, so basically that's what you're talking about here. We have the federal sentencing guidelines that you can take a look at. Your state probably has sentencing guidelines. Your states oftentimes have mandatory minimums. At the state level, mandatory minimums tend to come up when we're dealing with three-strike laws, habitual offender laws, things like that. Those are mandatory minimums. Most states have mandatory minimums for gun crimes, things like that. So take a look at your mandatory minimums and tie them clearly into your paper and the sentencing guidelines that are used for punishment. Let me check real quick here, make sure we don't address that later on down the line here. Let's see here. No. Okay, so let's get back up here to sentencing guidelines. So for example, in our particular scenario, we're talking about a bank robbery, and a bank robbery is a federal crime, and you're going to find that bank robbery statute under section 18 USC, United States Code 2113, and that's bank robbery. So when you look at punishment for bank robbery can be up to 20 years in prison. So if we go back to the sentencing guidelines, again, we're looking at the offense and we're also looking at an individual's criminal history. So when we go back to our scenario, as you will recall, two of our defendants were armed, right? Jed and Herman went in with shotguns. So there could be an armed allegation. So use of the firearm, which would be an enhancement, which means they're probably going to serve more time. Jed, on the other hand, based on the scenario, was also a previously convicted felon. So Jed's probably going to get more time than probably Herman. Jed and Herman, if I remember correctly, did not indicate any culpability in terms of being responsible for the offense, whereas Jane readily admitted her role in the bank robbery. So all of these things will take into consideration under the sentencing guidelines. So remember, the sentencing guidelines in part is designed to establish uniformity in sentencing. So you're taking into consideration not only the seriousness of the offense, but you're also looking at the particular offender in terms of his criminal history and the applicability of how we're going to punish that particular person based on the crime and his or her criminal history. Okay, so take a look at that. I've given you, again, the section. It's 18 USC 2113. That's the statute for bank robbery under the United States Code, and you can take a look at that and approach punishment from the sentencing guidelines perspective, and so I hope that helps. Next, we talk about judicial systems functionality. Determines how sentencing guidelines impact the functionality of the court and defends the response. So you've sort of already addressed that, but sentencing guidelines obviously does allow the court to function a little bit better because it provides the court with a basis for establishing punishment. And typically in the sentencing guidelines, it's going to be a range of months. And again, it's going to depend on the person's criminal history as well as the particular offense. So it does add a sense of uniformity in the sentencing process. So as some of you have stated, in effect, we're treating people who commit the same crime and have the same criminal history the same way. Okay, so tie that into that, and I'm sure you'll be fine. So that's that new section on sentencing guidelines. So you didn't include that as part of your milestones, but we did do a paper on that just recently. So that's what we're talking about there. You talked about calendar and dockets. Again, here we're going back and tying in some of those technologies that we talked about, e-filing. Several of you mentioned the PACER program that the federal government uses, and how each of these allows a more efficient and effective courtroom process in terms of not only calendaring and docketing. It also allows it to be a lot more accurate, and so that people have an idea, if the case is actually going to be in progress that week or not. Okay, and so that really adds a lot more efficiency. It doesn't necessarily mean that lawyers have to go in the court all the time. You don't have to transfer defendants to and from the courthouse if for whatever reason they find out that their case isn't going to go anyhow. So there's a lot of benefit to that, and you guys did a pretty good job on that part. But just remember, we're tying it all back to those couple of articles dealing with e-filing, some of the other elements that we talked about, case management, continuations model policy, things like that. So tie all of those in there. The only thing I would add here under administrative key role is include personnel. A lot of you include a different type of programs that courts have, but we're talking about the key role. Look at the individual, look at people whose jobs it is within the court system and their role in adding the effective layer of judicial efficiency. Okay. Next is the litigation process, and here we're talking about the process from, ideally from the time a person gets arrested until the time they're sentenced. So in my announcement this last week, I included a diagram for you on the criminal justice process, and that's what we're looking for. Now, the biggest difference I think you're going to find in the litigation process at the state and federal level is whether or not one uses a grand jury system or not. So some states that you guys live in use the grand jury as a means to bring charges against someone, determine whether or not there's probable cause to believe that individual did in fact engage in a particular illegal activity. Some states don't use the grand jury process. They use a preliminary hearing method to determine whether or not there's sufficient evidence to warrant somebody being held over for trial. So that is probably the biggest issue, and that's spelled out in that chart I gave you guys. So you can take a look at that when you talk about the litigation process. So it's pretty much the same, all except for that aspect, I think, of when you're determining and establishing probable cause, whether or not you're going to use a preliminary hearing or the grand jury system. Statute of limitations. Again, we talked about statute of limitations. I mentioned that in a recent video. And its impact on the judicial system. Again, part of the reason why we have statute of limitations is to, the longer a case is stale, the less likely witnesses are going to be able to recall specific types of issues and events and that type of stuff. And again, statute of limitations are often correlated closely to the seriousness of the crime. So in most states, misdemeanors have a 1-year statute of limitations, where some crimes, some more serious felony crimes might have a 3 to 5 year statute of limitations. Some crimes actually don't have a statute of limitations, okay? And the rest of this, I think, is pretty much all there. We talked about discovery. I talked about discovery a little bit, so you can take a look at that in my added lecture. That's in there, and the issues associated with discovery in both the criminal case and civil. Since we're talking about a criminal case, I focused on the criminal case. Here we're talking about the request for the continuance and so forth. We talked about the continuation and stuff like that. Okay, so hopefully that helps. I just want to touch on some of the key points, and I'm up to my 15-minute mark. So If you have any questions in the meantime, by all means, please contact me. Thank you.